Your case is coming up for trial and the defense tells you they've retained a medical expert to testify as an expert, but they don't tell you the dates of their witness's credentials. What can you do about it? Would you like to learn the answer? Come join me as I share with you this great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury trial attorney practicing law here in the state of New York. Now, your medical malpractice case is coming up for trial. Each side is obligated to notify the other side that they've retained various medical experts. In addition, we are required to notify the defense, and they're required to notify us, what our experts' credentials are. Where did they go to medical school? Where did they do their residency training? Where are they licensed to practice medicine? And are they board certified? Now, in addition, we are required to provide the dates that our expert graduated and finished each one of those things. What happens if the defense does not provide us that information? Well, here's what typically will happen. At the time of trial, we will ask the judge to prevent that expert from coming in and testifying. Why? At the time of trial, we will ask the trial judge to prevent this witness from coming in and testifying. Your Honor, we object to this witness testifying. What's your reason, counselor? The reason is that the defense has failed to provide us with the information necessary that they're required to under the law, indicating the dates upon which this witness completed their medical training, their residency, and when they're licensed. Now, why is that important? It's important because that will assist us prior to trial to doing research to try and identify who the medical expert is. And it'll give us an opportunity to prepare for this witness's cross-examination. If the defense fails to provide that information, there's a significant chance that we're going to be inhibited or prevented from trying to identify exactly who the medical expert is. Now, you might think that by exchanging expert witness information, we're required to provide the name of the medical expert that we've retained who's going to be coming in and testifying. Well, the reality is that that's not true. In New York, we do not provide the names of our experts to our adversaries. Instead, we are required to provide the credentials together with the dates in which they completed their training. Now, the reality is we can actually plug it into a computer program and identify who the expert is. Then we can do our research to see what the expert has done in the past and see if there's any dirt behind the expert. If the defense refuses to provide the information about when the expert completed their medical training, then we can ask the judge to preclude the witness, to prevent the witness from testifying, and then it'll be up to the judge to make that determination and whether or not the expert testifies. So why do I share this great information with you? I share it with you just to give you an insight and an understanding into what goes on in the litigation process in the steps leading up to a trial. You know, chances are you have questions or concerns about your own particular matter, and if your matter happened here in New York and you do have legal questions, what I encourage you to do is pick up the phone and call me. I can answer your legal questions. I do this every single day and I welcome your call. You can reach me at 516-487-8207 or by email at lawmed10@yahoo.com. I'm Gerry Oginski here in New York. Have a wonderful day.